Hello. Welcome to our YouTube channel. If you are new here, please subscribe. This is another video presentation featuring a question on corporation law asked in the 2014 bar exams. The question was, in an action for collection of a sum of money, the Regional Trial Court, RTC, of Makati City issued a decision finding D Securities, Incorporated liable to Rehouse Corporation for 10 million pesos. Subsequently, the writ of execution was issued but returned unsatisfied because D Securities had no more assets to satisfy the judgment. Rehouse moved for an alias writ of execution against Fairfield Bank, FB, the parent company of D Securities. FB opposed the motion on the grounds that it is a separate entity and that it was never made a party to the case. The RTC granted the motion and issued the alias writ of execution. In its resolution, the RTC relied on the following facts: 499,995 out of the 500,000 outstanding shares of stocks of D Securities are owned by FB. FB had actual knowledge of the subject matter of litigation, as the lawyers who represented D Securities are also the lawyers of FB. As an alter ego, there is no need for a finding of fraud or illegality before the doctrine of piercing the veil of corporate fiction can be applied. The RTC ratiocinated that being one and the same entity in the eyes of the law, the service of summons upon D Securities has bestowed jurisdiction over both the parent and wholly owned subsidiary. Is the RTC correct? This question is once again anchored on the doctrine of piercing the veil of corporate entity. The problem shows that the RTC applied to principle based on two facts. First, 499,995 out of the 500,000 outstanding shares of stocks of D Securities are owned by FB, and, second, FB had actual knowledge of the subject matter of litigation, as the lawyers who represented D Securities are also the lawyers of FB. Let us review first the three-pronged test to determine the application of the alter ego theory. First, control, not mere majority or complete stock control, but complete domination, not only of finances but of policy and business practice in respect to the transaction attacked, so that the corporate entity as to this transaction had at the time no separate mind, will or existence of its own. Second, such control must have been used by the defendant to commit fraud or wrong, to perpetuate the violation of a statutory or other positive legal duty, or dishonest and unjust act in contravention of plaintiff's legal right, and third, the aforesaid control and breach of duty must have proximately caused the injury or unjust loss complained of. Virata vs. We, GR number 220926, July 5, 2017. None of these were shown in the problem. What was shown only was the FB-owned complete stock control over D Securities, Incorporate, but nothing more after that. Also, contrary to the pronouncement made by the RTC that in alter ego principle, there is no need for a finding of fraud or illegality before the doctrine can be applied, the jurisprudence on the matter tells otherwise. The suggested answer is no, the RTC is not correct. The doctrine of piercing the corporate veil does not apply in this case. There are requirements before the said doctrine is applied based on the alter ego principle. It must be shown that there must be complete domination, not only of finances but of policy and business practice in respect to the transaction attacked. Such control must also be used by the defendant to commit the fraud, and that must be the proximate cause of the injury. None of the above requisites were shown in the problem except that FB has complete stock control on D Securities. We hope you learned something useful in this video. Thank you. If you liked this video, please subscribe to our channel and like our Facebook page ECS Notes. You may also comment and share this video to your friends. Have a pleasant day.